whatever it is, and you make a list of your assets. But coupled with that, you normally have liabilities. That house very often has a bond. So you have to make provision for the payment or the dealing with the bond, because an estate cannot be finalized until all the issues have been finalized. So if there's a bond, cash has to be achieved to settle the bond, or someone has to take over the bond in recognition of getting the article beforehand. So this is all part of the family's planning situation. The car may be still on lease, on hire purchase. Once again, if that comes with its own problems. So in allocating the car to someone, it comes coupled with all the issues that go with the car. It's the point I'm trying to make is that this is a going concern. You've got to have all your thoughts together, all your assets, all your liabilities in a summary and see where you stand. Then we have the added problem. A lot of people have set up trusts, and suddenly there are assets in this trust that need to be dealt with. Do you wind up the trust? Do you distribute the, the assets in the trust, or do you allow the trust just to carry on? You need to get suitable advice. It's very difficult to talk about that in such a short space of time, because trusts can be very complicated. They were obviously set up for a reason. One needs to get suitable advice as to how to handle them. But in a nutshell, the trust does not have to be wound up as part of the winding up of an estate. But, if you have people who are going to be beneficiaries of the estate living in America, living in Australia, they are living in a country that does not recognize South African trusts. As far as they are concerned, the South African trust is meaningless. The asset, in fact, belongs to the individual, not to the trust. And there are other complications arising from that. And this is a trend worldwide that lots of countries are slowly starting to view a trust as an instrument that a lot of people have used to hide assets, to to sort out things that should have been disclosed, and they try and hide these assets in the trust. So when there's a trust, and in particular, if there are foreign beneficiaries, at the moment, your problem beneficiaries are the Americans and the Australians, because those trusts are not recognized. But as time goes on, there's every chance that this non-recognition of trusts could be expanded to those countries, to other countries as well. So that's your broad base of your assets and your liabilities. Your biggest liability, well, not always your biggest liability, but a liability that is overlooked is your estate duty. With every estate, there is the question of an estate duty calculation. How it works, there's a rebate, an automatic rebate of 3,500 rand, 3.5 million, sorry. 3.5 million, you should be doing this. 3.5 million rand rebate per person. So if it's a husband and a wife, there's a rebate of 3.5 million, or if it's both, it's 7 million rebate. How that works, if the husband leaves everything to his wife, or the wife leaves everything to her husband, and there will be a double rebate, a total of 7 million rand, and there is no estate duty if everything is left to the surviving spouse. So, or one could leave up to 3.5 million rand to people other than the surviving spouse, and still no estate duty. The moment you overstep the 3.5 million rand mark, you then have estate duty. And until in an estate, until you have paid all your liabilities, including estate duty, the estate cannot be wound up. If it can't pay those duties, you might end up with an insolvent estate. So once again, the importance of planning your way forward so that you don't end up in that predicament. If the assets are left to the surviving spouse then accepts those assets or whatever's been allocated to him or her, and they go forward. In that first estate, there is no estate duty. There are normal costs, which I'll deal with in a moment, but there is no estate duty applicable in that particular case. Am I still getting through to the back? Thank you. I'm trying. So let's deal with those particular assets. Coming back to the house. The house is, let's say, allocated to one child or to 3 children or to whoever. Then the transfer to the beneficiary or beneficiaries is done by a conveyancer who will be appointed, and there are no transfer duties on a transfer within an estate. There's only the conveyancing fees that need to be paid to the outside conveyancer. This then gets transferred to the 1 person, the 2, the 3 people, however is dictated in the will. By the way, the beneficiaries are entitled to rearrange the assets more suitably if we have that example of your 3 people and inheriting one house, and there's cash elsewhere, and there's a reshuffle of shares. So the 3 people can get together, they can decide on a redistribution of assets between them, and they can sign an agreement between them, and this is accepted by the master. The important thing is the master does not allow you to deviate from the basic will. So, but if the beneficiaries internally rearrange assets or restructure anything, as long as it's agreed to, the total amount must be correct to the cent. The master will not allow any deviation, any variation in the arrangement. Then this is now recorded in the assets of the estate and in the affairs of the estate, and this redistribution will be allowed. So the house, in my example, can now be given to 1 person who needs it more, and the other 2, in my example, can get other assets, so that we have between the 3 beneficiaries a situation where all are happy with what is going on. You then come to the car. When you're looking at the car, the car is a simple matter. You go to a garage, a motor dealer, and you get a valuation from your reputable dealer. That is now the value of the car. Likewise, with a house, you go to a suitable estate agent who operates in that particular area, and they'll give a valuation of the asset and so on. So, but with a car, it becomes more involved because cars are often on lease, on hire purchase, on other arrangements. So there is a debt in taking over the car. There's a debt that has to be recognized. So in looking at your assets and your liabilities, you've got to recognize the car as an asset and the burden that comes with it as a liability. So in your planning, you would have your list of assets, you'd have your list of liabilities, and that's how you would record it. We then come to the company, where the deceased had an interest in this company, a certain percentage, whatever. The company is an ongoing thing. Companies don't die. They might cease to exist, but they don't have a formal dissolution as such. One would have to get together with the auditor or the accountant of the company, arrange for a proper valuation, and this valuation has got to be endorsed by SARS. SARS have got a particular chap in Pretoria who gets these valuations for perusal. He goes through them, he checks them out, and if he's happy, if he has queries, he'll raise the queries that be dealt with. So at the end of this little operation, there will be a proper valuation and an agreed one with SARS. The company, once again, could be part of the reconstruction of the assets within the beneficiaries, or it could be allocated directly to one person. Also, with a company, it's usually a lot more complicated. Very often, if there are other shareholders, there might be a shareholders agreement. The agreement might dictate the manner in which things are to be resolved. Are the other shareholders going to buy out this particular one who's now passed on, or is there a dissolution of the company? All of those things have got to be looked at so that the company in its structure can be sorted out and dealt with properly. With the question of shares, it goes further. You might have shares on the stock exchange in the public domain. The actual valuation of those shares is very simple. You look at the stock exchange listing for the day, and on that day, the price of that particular stock is shown, and that is your valuation. The complication comes these days, there are lots of opportunities to buy into the stock exchange with borrowed monies. So when you're looking at the stock exchange asset, you have to deal with the stock exchange liability to get an overview of the real value of the entity. So the principle I'm trying to explain to you goes out with all assets and all liabilities in the estate. You might have credit cards. Most people do have credit cards, and at any point of time, you'll probably be owing the bank a certain sum of money. So at that point of time, the amount owing will be established. The bank, once they become aware that a person has passed on, they will then freeze all accounts for that person. What a lot of people do, they're naughty, they carry on drawing as much as they can. They deplete all the value in the bank accounts, and they buy in what they can before the banks come to be notified of this passing and before things are blocked. If that happens, the executor, when he or she gets appointed, they have got to backtrack to the exact date, and they will redirect all the figures as at the appointed date. So, but in the meantime, the husband or the wife who survived has already got the money, and who knows what they've done with it. But it does get picked up in that way. It's all dealt with. There's no quick fixes on that sort of thing. So coming back now to my little example, we look at the house. If it's the surviving spouse that's getting it, no problem. It gets transferred across to him or her, and it's done. If it's not going to the surviving spouse, we just have to now transfer it to the individuals involved, the beneficiaries as nominated. That is done by the conveyancer, who will then transfer it accordingly to the people. And in that way, the assets will all be dealt with in the same manner. Now we come to the important part, the estate duty. If it's not to a surviving spouse, then there is estate duty. You've got your basic rebate of 3.5 million rand per person. So if we're dealing with the first person to pass on, it's 3.5 million rebate. If everything went to the initial survivor and now it's an estate out of the subsequent survivor's estate, we're talking of 7 million and rebate. After that rebate, then estate duty is applicable at 20% on the first 30 million rand of value. And if it exceeds 30 million, then it's 25% on the balance. So when one is setting up your structure, your planning device, you need to record the estate duty as an item because it could be very important in your calculations. We have other assets that also might be around. You have insurance policies. Let's say the husband passes away and there's a policy in favor of the wife, and that is not his policy, it's a policy payable to the wife. In that case, that policy is not part of the estate, but for estate duty purposes, it's treated as a deemed asset. It's deemed to belong to the estate, even though it's not an estate item. So it will be paid to the beneficiary, but when we come to the estate duty calculation, we have to bring that in as a deemed asset, even though it doesn't show in the basic document. The basic document is an L&D account, liquidation and distribution account. But it will show in the later pages of that L&D account because it's part of the whole cycle, but not of the main issue. On someone passing on, the arrangement with the master's office, by the way, everyone refers to the master. He or she is the person who's in charge of that department, but you don't actually deal with the person, but superficially, if there's a query or whatever problem, you'll always be referring to the master with a capital M. The master runs the show. So we have this situation. You've now planned your setup. You're now ready to put things together. The question of estate duty comes to the fore. You add up all your assets according to the valuations, remembering that valuations, every valuation has got to be supported by a document. The dwelling, the car, by people who are able to do those kind of valuations, the company with its shares by the auditor or appropriate person to do that valuation and so on. All those valuations have got to be submitted. Every single document that gets dealt with in the master's office has got to be supported by a suitable document. This goes all the way down the line. So we then go the actual calculation of the estate duty, as I said from the tables I just gave you just now, then you have 12 months from the date of the person passing away to settle the estate duty commitment. Most estates at that stage are not ready to be finalized. There's still an awful lot to be done. So no problem, the master will give you time, but interest starts amounting from that moment onwards. Okay, so those are your basic rules of getting the estate organized. So now let's go to the will. In drawing the will, step one, you need to appoint an executor. The executor can be anybody. It does not have to be a person, a professional who operates in that particular field. It can be to the surviving spouse, it can be to a child, whoever. And if that person needs help, they can go and get the help. The beauty of appointing someone, if there is someone in the family, is that even if they're not knowledgeable on the matter, they can then go and get a suitable executor to do the work, but they can ensure that the fees are reasonable. If you just appoint a bank, for example, or one of these financial institutions, the tariff rate is 3.5%. And rest assured, whether the estate has got 100 Rand in it or 100 million Rand in it, they will probably be charging 3.5%. And for a small estate, 3.5% doesn't even cover. But for a very, very big estate, it's absurdly too high. But the banks have a notion of saying the fee will be the maximum allowed in terms of the Act. So if a member of the family, the wife, the kid, and whatever, is appointed as the executor, you have the advantage that that person who's now been appointed as an executor can negotiate and talk to the ultimate executor to arrange a reasonable and responsible arrangement on that situation. So then once the actual procedure goes like this, the person passes on, there's a will. In the will, if the executor is nominated in the will, then that is the person that will be appointed. Very, very unlikely that the master will not appoint that particular person. It is the wish of the person. That is what it will be. If the person lives in South Africa, and if the will states that the person does not have to provide security, then they do not have to provide security. By security, effectively, it's an insurance policy. So the master says, if the person who passes on trusts the appointee, that's okay with him. But if he doesn't trust the appointee, doesn't give this exemption on security, then he wants an insurance policy to cover the total value of the estate. So in other words, if the executor squanders the money, the beneficiaries will not lose out. And that policy holds good for a year and is renewed every year until such time as the estate is wound up. And the master will not allow the estate to be wound up until he's got clearances on all these issues. So the master, to appoint the executor, he wants the original will. The original will must be signed by the person drawing up the will, preferably not initials, but signed on every page in full. Two witnesses to sign on every page in full. Sometimes the master allows initials to go through for the witnesses, but it's better to play safe and go for a full signature. The master then wants various other documents to be submitted, the ID and a list of other issues, these details of the particular person, etc., etc. There's about 8 or 10 different things and forms that have to be completed. It's sent to the master, they consider it, and they then issue an appointment. Until that moment, no one has any rights. Everything is effectively frozen. If someone goes to the bank and draws money or does other things, manipulating the money or rearranging or selling the motor car because they believe it's going to come to them, that is fraud. Normally it slips through, but that is fraud. So when the master is happy that everything is okay, he makes the appointment. At that point of time, the administration of the estate starts. So the procedure now is, it's incumbent upon the executor now to meet with the family to discuss the will, You don't have to have a reading of the will as it shows in the movies. You just have a frank discussion. You analyze it and you see what it says and see in what way is it going to be utilized by the family. Uh, that's an important discussion. And also arising from that discussion, the executor can now get an idea, is there going to be the need for a reshuffle of assets to accommodate the beneficiary that needs the house as opposed to the beneficiary that wants the cash or the shares in in that company or whatever. That reshuffle can be done, but only if there's 100% consent with every person involved in that reshuffle. If they don't all sign fully, a reshuffle will not take place. And then the estate will just carry on as it was. The master has got no discretion whatsoever. I was involved in a will some time back, and the one clause read that the executor has the right to dish out 1 million rand to charities of his or her choice. The master threw that out. It was a discretion given to the executor. It does not, it can't go through. The executor must follow the rules of the legislature, must follow the rules of the will, and do exactly what is set out in that document. The executor cannot make his or her own decision and decide that there's a better charity to get a benefit of, or the one child needs more than the other. The executor has no such rights. The executor then has to, after he or she has got everything together, then an advertisement must be placed in the local newspaper where the deceased stayed and in the government gazette, giving people 3 weeks to lodge any claims that they have against the estate or to claim anything that they believe that first of all, to claim what the estate owes them and to make arrangements to pay in what they should in order to get the estate wound up. The master has the right to summons, to issue warrants, whatever, if he needs it in order to administer the estate. It's like running a company. An important thing with an estate is if the deceased has young children or believes that certain of the beneficiaries are not ready to inherit what's coming their way. Quite a common one is we'll give you half at age 25, and then if you've messed up, we'll give you the other half at age 30. But the will can be drawn in any way you wish. But you can't allocate anything to someone before they are major, before they turn 18. So if there's a will that says half age 25, half age 30, then what we have to do, and those beneficiaries have not reached those ages yet, we have to have a trust within the will, known as a testamentary trust. It's a trust out of the last will and testament of the person. That trust will have powers for the trustees to do their job of work. Those trustees do not have to be the executor. The best solution I would suggest for those trustees is to have one who knows the family situation so they can deal with the family needs of the beneficiaries, and the other trustee is someone who has some financial background so they can make financial decisions with whatever assets are being looked after in the trust. So that trust will carry on until age 25, and then the necessary distributions. If the trust deed says that each beneficiary will get on turning 25, and there's 3 beneficiaries, there will be 3 distributions. And then at age 30, there will be a further 3 distributions, and then the duties of the trustees will fall away, and that will be the end of it. So that will be how that is dealt with. The other point, if there is, or if there are, excuse my grammar, if there are minor children in the estate who are beneficiaries, one needs to appoint a guardian. The guardian will have authority. The initial guardian will be the surviving spouse if there is a surviving spouse. If there is not a surviving spouse, then one should appoint a guardian. And the guardian, once again, ideally, if there's a lot of money involved, best to have two people appointed, one on the family side, one on the financial side, in order to see that it's properly dealt with. Because the guardians have now got to look after those children, allocate to them what's needed. And if the age, for example, is 25 and 30, my little example, then they'll remain on up to age 18. At age 18, they fall out of the picture because they have no more rights. Then the trustees will take over from age 18 up to 25 and up to 30. So they'll be in a position to do whatever they need to be done. I think at this stage, I'm going to ask if there's any questions, and let's try and handle it. Sorry, ladies first. The question is, if there's a special needs child in the family, that's very important as part of your planning. And when the initial person sets up his will, I say he, but obviously he or she, it's when they set up his will, he should recognize that and make provision for that need. And money should be allocated, assets should be allocated, a person should be appointed as the guardian or whatever the term is of that child. That is up to them. The executor, if the will is silent, the executor has got no right to identify a special needs child and say, I will help you. The child is just another beneficiary. So it's up to the person in your initial planning to make arrangements for all those things so that you suitably deal with it. So that planning of your will, that drawing up of your will, is one of the most important tasks that you're ever going to do in your life, because your whole thereafter future, your legacy, as they call it, etc., that all depends on what you put into that will. And if you don't give thought to it, and if you don't recognize different children or different issues, you are going to come unstuck and you will not have done your job of work. Another point that I must also mention, often the parent or the grandparent will say, you know, I love my children, I love my grandchildren, I want each of them to have 1,000 rand. So then, and the will has got, let's say, this provision of half age 25, half age 30. Now, because of that 1,000 rand, that estate has got to go on to age 25 and up to age 30 because there's still a payment due to be made. So if the thought is to give 1,000 rand or whatever, do it now, but don't have the estate delayed. Another point also to bear in mind, there have been cases of this where a will said that I want a certain amount to all my children and all my grandchildren whenever they might be born. That estate can't be finalized because those grandchildren can arrive later. So the estate has got to be kept open for that purpose. And there have been such cases, they've gone to court. The court has eventually ruled that the estate can be wound up, but why go to all that trouble, cost, and aggravation on something that is futile? So if it's a meaningful amount, then you use your 25 or 30 or 21 or whatever number you choose to use. But then be practical, but don't do things that are going to deter the whole situation. Right, you want to? Yeah, thank you. Very important point. Thank you. A very important point when you're doing an estate. Well, a South African taxpayer, first of all, pays tax on all income worldwide. This was brought into force a number of years ago. If you have income in any country in the world, you pay tax in South Africa. There are DTAs, double tax agreements with most countries, which do make variations to that. But in basic principle, there is tax payable by a South African resident on worldwide income. Then in an estate, the estate will consist of assets worldwide, all assets over the whole world. If there are assets in another country, it is advisable, strongly recommended, to have a will drawn. You can have a will which just basically says, this is in respect of all my assets in Israel, all my assets in Russia, if they are any, all my assets wherever they are. So you would have a separate will for each country if you have multiple assets. But it's important to have a will in each country because each country has got their own terms and rules of how they deal with an estate, what they call the probate. So it's best that you have a proper will to obviate all those problems. And your last point on that is that will does not have to have the same executor that you have locally. It does not have to have the same beneficiaries that you have locally. You might have a child in America and then an asset in America. The asset could go to that child because it makes sense there and you do redistribution elsewhere. Okay, sorry. No. Uh, yes, you're entitled to, you do not have to leave your assets to any particular person. You can leave your assets to the SPCA or to your girlfriend from earlier years or whatever. But you're entitled to do that. And you're also entitled to make stipulations. If I'm leaving it to that person, but if they do not survive me, then the children or family of that person is not going to get anything, it then goes to someone else. You're entitled to reshuffle as you wish. There's no hindrance whatsoever. By the way, in a will, you often see the word Presentaion. That means that the allocation is to the person. Let's say, my example of the 3 children, you leave to the 3 children Presentaion. If one of those children were to pass on before they inherited, then it goes down the line to that person's children. And so if that person has 5 children, for example, they'll share the 1/3 between those 5, and they'll share it equally. But Presentaion doesn't include a wife, it only includes direct descendants. Sorry. You should. Of course, that's why when I was talking about the planning of the trust, of the will, that's part of your planning. If you have a special needs child, you need to provide, either by setting up a special trust, which has certain tax benefits and so on. You do that, or you make some other provision, or you allocate an amount to someone who will be the guardian of that. But you make arrangements, or you make a sum of money allocated to a charity that takes in such people to look after them. But you have to plan it. The executor cannot change the rules. The family, oh, so and so forgot to make provision for such. Too late. It's gone. The planning is so important. Uh, the, we have to then, first of all, we look at the how they married. If there's no ANC document, if there's no ANC, then it is in community of property. So it's half-half. But if they married in the accrual system, we have to look at the ANC, the antenuptial contract, and the antenuptial contract normally talks about assets brought into the marriage at time of the marriage, and then assets that were accumulated thereafter. And if assets that have accumulated thereafter have to be disclosed, the executor has the legal right to demand disclosure. He has full and complete legal right. Then you can go to the lawyers, go to the law, and they can do whatever they can do to obtain that information. They can force it. No question. No. Sorry, just say it again. No. Yes. Look, first of all, ideally, when you do the will, you want to think of all the options. But in your question, you didn't make mention in the will of what will happen to that company. Remember one important point: the will doesn't have to specify any asset. It can talk of percentages. It can sort of assets in Doornfontein must go to so and so, and in Cape Town must go to so and so. It doesn't have to specify in any way whatsoever. So the executor has got to respect any contract that has taken place beforehand. So if a contract took place beforehand, allocating the shares in that company to X, then the executor will, that's part of his administration, he will recognize. I mean, how would you deal with a joint account? Uh, that okay. Yes. Okay. The question is, you have a joint bank account, and now a person has passed on, and the survivor is now prejudiced because he or she can't get access to their money. First of all, once it's frozen, it is frozen. It is up to the executor when he's appointed to come and fix up things and sort it out. But you have a planning problem here, because the person who drew up the will should have thought of this beforehand. Ideally, until the executive is appointed, it should take about 2 weeks. But often there's a hold-up. Like the death certificate can't be obtained from the department. The original will can't be found, and we only got a copy, and we're still digging for the original, and so on and so forth. In the meantime, the survivor has got to live. It is incumbent upon people who are forward-thinking to make provision for, let's say, 3 months worth of living cash to carry them through. Otherwise, they could get into trouble. Until the executive is appointed, he has no power. The surviving spouse could come along and say, "It's half of that is my money, I want it." He has no power. If he goes to the bank, they will not recognize him. He's not appointed. So this is part of your planning process, that one should cater for that sort of thing. Most appointees take place within 2 weeks, and one can survive for 2 weeks somehow or other. But there are cases where it delays, and then we have a problem. At the time of drawing up the will, sorry, your question is, isn't the executor appointed at the time of drawing the will? Yes. But the will is just a piece of paper. I hereby appoint Joseph as the executor in my estate. It's a name. Later on, I can decide I don't like Joseph anymore, and I'll appoint someone else, and so on and so on. Later, I decide to tear up that will, and I draw a new will. So that appointment has no validity. The will is not registered anywhere. When there's an estate, there's a rush to go and find wills. If you find 3 wills, different dates, the latest dated will apply. And you might have appointed that person in your first will, but in between 2 other wills have been drawn. The latest one is the one that applies. So it doesn't overcome that problem. Yeah. Okay, well, last questions. Okay, sorry. Yeah. Yeah, okay. Yes, I will. I will. Thank you. The question is, your wife has had an accident and can't get around, and now you want to make a change to your will, but she has to sign the document. There is the best solution there is to find someone who's prepared to come to your home, and in your presence with the 2 witnesses present there to agree to the document, and for your wife to sign and the witnesses to sign. If she's unable to sign, then you need to have a doctor who certify to that effect. The doctor will say that this lady was not able to sign herself. In my presence, I witnessed it, and on her authority, I'm now signing. And he signs in that capacity and puts the suitable wording in, and that document is done. Yes. Yeah. Sorry, can I just have a last point? If there's any specific questions, With pleasure, please ask me, I'll try and answer it for you. Then, sorry, how'd you get it up? Oh, wasn't sure about the
No, it wasn't coming through at the beginning, but it's working. It's rockets.
Okay, good afternoon. I'm Herb Lewis. I'm going to provide an extension of what Russell had to say in terms of how we bequeath, dispose of our investments at the time of our death. And there are three things I want you to remind me about in case I forget to mention them. The first is past girlfriends. Can you remember to do that? Okay. The second thing that we're going to discuss is investing offshore. Okay. Russell mentioned certain complexity with that, and we'll discuss ways and means around that. And the third thing that we're going to mention is for all the complexity and the bureaucracy and the time delays and the frustration that Russell made mention of, we're going to look for legal schemes and arrangements to circumvent that. Okay, quite legally. Okay, so what distinguishes an investment from the house and the company and the trust that Russell made mention of? And there are a few things that distinguish investments. The first is that they are liquid. They are immediately convertible to cash. They are immediately accessible. And if you can access them, you can dispose of them immediately. The second thing to remember about investments is that it's the primary source of wealth for most people. Husband passes away, bills are due the very next month. So there's the requirement for the urgency of transfer, correct? And the third thing about investments is that they are in some ways more strictly regulated than your house or your company because, and we'll get back to the idea of your old girlfriend, because the old girlfriend features all over the place. And old girlfriends generally do, right? One never, okay, so, but we'll get on to old girlfriends. Yes, Dan. Old boyfriend, absolutely. I mean, that's very sexist of me. Old boyfriends too, absolutely. Okay, so one thing I can say is the investment industry in this country is the most sophisticated in the world. It absolutely is. From the nature of the products, which we're going to have a look at in a second, to the systems that administer our wealth, to the laws that govern our wealth. It is the most sophisticated in the world. And let's discuss how that all works. Okay, so before we can discuss what happens to each of our investments, we need to classify our investments, how they classify, because without that, we don't really know what their treatment is at death. So it's interesting that we're going to spend about, how long do we have, Uncle Frank? 25 minutes, 20 minutes? Okay, so we have 20 or 25 minutes to teach you the investment industry from start to finish. That's a challenge, right? And the second thing that's important, but we can meet these challenges because we're very competitive and we're determined that we can meet these challenges. And the second thing is that the investment industry is supposedly confusing, opaque, convoluted, widespread, endless scope. And in some ways it is. In fact, even people in allied professions, accountants and lawyers, don't completely understand the mechanics of the investment industry, not because of its complexity, but because it's not well explained. And if it was explained simply to meet practical needs, it would be far more easily understood. Okay, so let's have a squiz. Everyone can hear me? Okay. Okay, so we're going to go through, let me jump ahead slightly. All right. The first thing we're going to do is discuss the range of investment products quickly. So this is, if you like, a timeline, a chronology. This is my favorite slide, and that's the one I handed out. And this tells you the full range of investment products in the country, in the world. There aren't any more than this. They take different names, they slight variations or derivatives, but this is the scope of the investment world because they accommodate every investment need or requirement. So let's have a look at this vertical line over here. Can you see this vertical line over here? This line to the left of the word living annuity. You got that one, right? So let's call everything to the left over here the accumulation phase. So from the time that you start earning a living, you are generally putting away small amounts of money. And you're doing so to try and build as big a pot as possible until retirement, which is that vertical line. And at retirement, you're going to transfer that money into a pension, correct? And so instead of accumulating, you're going to draw down on what you've accumulated. And we're going to focus primarily on the drawdown phase, which is to the right of the vertical line. The other important classification is the distinction in our, and it matters here, in our accumulation phase over here. When we accumulate, in fact, maybe I can even use a pointer here and you'll tell me, well, it's easier like this. Okay, so can you see there's a horizontal line over there, thick line. It separates the top from the bottom. It's important to make a distinction between retirement funding money that will eventually become your pension and non-retirement funding money, money in the bank, money in a share portfolio, money in a unit trust fund. But the distinction between retirement funding money and discretionary money is a very important one in terms of what happens at death. Okay. And then we come to our post-retirement years, where many of you are, and you're going to take the proceeds of your retirement funds and purchase one or other pension. Just by the way, this terminology, the word annuity, in the Oxford English Dictionary, and the definition is an income stream. So a living annuity or a guaranteed annuity or a pension is an income stream back to you from your investment, whereas this word retirement annuity that we'll come to now is an income stream out of your pocket into the investment. So there's just, we need to know the distinction. A retirement annuity is an accumulation or a funding product. A living annuity or guaranteed annuity or a pension is money coming back to you, opposite sides of the coin. Okay, so let's have a look at what happens at the time of death. There are 4 retirement funding products in this country, in any country. You've got a pension or provident fund at work. Membership is compulsory, thank goodness, otherwise we wouldn't save anything, correct? We've paid ourselves first. If you want to self-fund or you're not part of a company pension fund, you would have invested in one or more retirement annuities. And on exiting a company to join another company, you would preserve that wealth in a preservation fund. So that would be, if you like, an individual pension fund, if you like, that originates from a prior pension or provident fund. So those are the 4, and there are only 4, retirement funding or accumulation products that we have. And at retirement, we have this pot of money, ideally as big a pot as possible. And we then use that to draw down an income, a post-retirement annuity back into our pockets. And there are 2 types in this country, and you'd be familiar with them, I'm sure. The one is the living annuity. It's a South African invention, 1992. And the idea is quite simple. We'll come back to it in a second. Let's look at the traditional or original guaranteed annuity. You give a life assurer, an investment administrator, your money, and they will guarantee to pay you back an income with an escalation, without an escalation, and with or without provision for a spouse or for a dependent, should you predecease your spouse. Okay, we'll come back to this, but it's important to understand what these investments are before you discuss the treatment at death. Okay, so you give your money, the guaranteed annuity. The word guarantee originates from the fact that your income is guaranteed. It doesn't matter what Putin does in Russia. It doesn't matter what financial markets do. Nothing matters. The life assurer has made a commitment to pay you an income for life, and possibly with an escalation for as long as you live. Important. Why wouldn't everyone buy these things? Because there are 2 shortcomings with these things. The first shortcoming is that on your death, generally, either nothing passes to your spouse or only a portion of your pension passes to your spouse. We'll come on to the specifics. But no lump sum passes to your spouse. And on the death of the surviving spouse, of the last to die, nothing passes to the children. So that's the first limitation of a guaranteed annuity. So the enticing thing about it is the certainty of income. Okay. The downside is that your spouse gets part of an income, or an income only for a short period of time on your death, or nothing. We'll discuss that. And nothing passes on to future generations. Okay. The other shortcoming about this type of investment is that the income rate, the growth rate on which that monthly income is based is quite conservative. But still, the appeal is the certainty. The living annuity pension, which many of you may have, obviously, your wealth at retirement is transferred into this investment from which you draw down your own money. The beauty about that, now it's a tricky thing because there's a little bit of risk and many of you may have this. Obviously, there are responsibilities that fall on two parties. Number one, the investment advisor needs to get you an 8 to 10% return. Number two, you need to be drawing down less than the investment return. Otherwise, your money's going to run out. So there are projections that show how these things are done, but the risks fall on the advisor and the financial markets to get you your 8 to 10%, and your risk, or the risk that you present, if you like, of not running down your money too quickly. On your death, the money passes to your beneficiary, a lump sum of money, and they then decide how much of an income within parameters that they wish to draw. And on the death of the second to die, the money passes to the children. Now, the reason that I'm classifying retirement funding products from non-retirement funding or discretionary is because the top part of the screen, retirement funding products and post-retirement products, don't fall within your will. They are not part of your estate. And that's a very positive thing. Why? Because number one, there's an urgency to get the money to the beneficiary. They need to pay the next month's expenses. So in a living annuity, the transfer of the capital is immediate, and it necessarily is. And I get back to the sophistication of the industry in this country. Within a month. And it happens all the time that unexpectedly often, partner dies or spouse dies and the transfer of money has to happen, and these things happen speedily, which is why it necessarily needs to be outside of an estate. You can't have these things administered right. Russell spoke about the urgency of accessing money in the case of a joint bank account where you can't get your money. So that is a practical example of how this need is addressed in such a case. And it passes down generations. In the case of a guaranteed annuity, if you're receiving a so-called pension, you need to check on what the provisions of that pension are. Is that what happens at the time of your death? Because there are many variations. There's no single rule on that. Generally, and I'll tell you how the different combinations in which they come. Generally, when you buy this guaranteed annuity, the life assurer agrees to pay for 10 or 20 years. It will pay who's ever alive. So spouse dies within year number 5, and there's a guaranteed annuity for 10 years. For another 5 years, because it's only payable from 10 years from the date it was taken out, from the date you went on pension. Only for another 5 years is it paid to the beneficiary. Or there's another variation of that, and that's it paid for life to the surviving spouse. The problem with that is that the income you get is going to get pretty small, because now the life assurer is saying, well, one thing for the husband to live long, but now he's got a much younger wife and she's going to live for another 50 years. So the income that we're going to pay is going to be dramatically lower because we're now paying for 2 lives. You agree with me? So, but the point being over here, that it falls outside of the ambit of one's estate. There's no administrative complexity, delay, etc., etc. And that the other thing about that is because it falls outside of one's estate, no estate duty. So you can see the benefits here of having these investments outside of one's estate. Okay. An interesting thing about you name your beneficiaries, guaranteed annuity, living annuity, you specify your beneficiaries, but the test in terms of satisfying the requirements are a lot more stringent than they are in a will. You can't name whoever you want to. And now let's get back to our old boyfriends and girlfriends. So what happened, and I'm pretty accurate in describing what happened. Old Jan Kruger in the Free State died. And they came to read out the will, and there they were sitting at the Procurator's office, and he said, I bequeath 70% of my estate to my Poppy Mariki and the remaining 30 to the SPCA. Something like that really did happen pretty close. And the government decided, you know what, this is a step too far. We can't allow for this. So they separated the bequest, the transfer of monies within pension funds from the rest of your estate, exactly for this reason. You don't have carte blanche decision as to who's going to get your pension fund money. Financial dependents, spouses and children get it. And the trustees within an investment company, an Allen Gray, 91, Momentum, or whoever, they make a determination that the person that you've elected gets the money. And if it's a financial dependent, they get it immediately because of the necessity of financial need. So it works particularly well, and it necessarily works that way. Okay, now we come on to any questions. Is there anything that are quite happy with so far? Okay, so now we come to non-retirement funding monies. This is what Russell was referring to. These things are not governed by the Pension Funds Act as the products at the top are. Here, the assets fall within your estate. And there's the delay. And there's the frustration. And there's the need to access money from. And what is a discretionary investment? Well, it's an investment generally. It's money in the bank, I suppose, at its most basic form. And we'll go through all of these. It's shares on the stock exchange, it's tax-free savings accounts, et cetera, et cetera. There, the assets are governed or apportioned in terms of your will. There's one exception to that, and that's something called an endowment. An endowment is actually an insurance policy. It's governed by the Long-Term Insurance Act, and an endowment allows you to specify a beneficiary. And the beauty about that is that on the death of the investor in the endowment, and I'll tell you its characteristics, but on the death of the investor in the endowment, because there's a designated beneficiary, and that beneficiary, by the way, can be anyone because it's not governed by the Pension Funds Act there, it can be anyone, but generally, responsible people do the right thing. It's the spouse and the financial dependents. Because there's a designated beneficiary, it's paid immediately by the investment house or the insurance company to the beneficiary. And I'm going to come to offshore as well in a second. So they get the money immediately, speedily. The executor is made aware that such an investment existed. It's not administered by the executor, so there are no executor's fees because they didn't do anything. But it is subject to estate duty, as Russell described previously. But the benefit about this is it greatly facilitates the transfer of wealth immediately outside of the will to the recipient, to the intended beneficiary. And the general rule, as Russell reinforced, is that you want to keep as much as possible outside of the ambit of government. That you really want to do, and especially in this country. So the master should have as little a role as possible. Not easy with fixed assets. Again, what characterizes investments from what Russell spoke about? These things are liquid. These can be in cash. They're accessible. And they're immediately available. And there's discretion to kind of circumvent the master. And you need to exploit those kind of things. Okay, so the rest of these babies over here fall within the ambit of your estate. So let me give you some. So are we happy with this classification? We've got this retirement funding products over here, and then we take that pot of money and we can withdraw some of that. So I'm not going to discuss that, but you can withdraw some of what you've accumulated during retirement, tax-free, and you take more than 500,000 Rand, you've got to start paying tax on that. But let's assume for the moment that you have a pension. So now we've got pre-retirement, post-retirement, governed by the Pension Funds Act, governed by the Long-Term Insurance Act. The money falls outside of your estate. That's the key point between top half and bottom half. Falls within your estate, but money in an endowment with a designated beneficiary gets paid directly to the beneficiary immediately. The delay is not the master. The master doesn't handle it. It's the speed at which the administrator can transfer wealth to beneficiary. Okay, so let's consider what Russell said about overseas money. So if you invest overseas and you invest through a South African administrator, that money is still governed by your South African will. So you have a share portfolio, or more commonly a unit trust portfolio. Unit trust is just an investment managed by a professional on your behalf because you don't want to be choosing the shares yourself. So you outsource it to an investment manager for a fee. Allen Gray Balanced Fund, Coronation Balanced Fund. You're familiar with all of those. Okay. If you invest into these unit trust funds. Okay, before I proceed any further, we need to make this distinction between an investment product and a unit trust fund. Okay, that's important. So an investment product like this determines the treatment at death. It also determines the accessibility to your money. You can't just withdraw all your money in a living annuity or in a retirement annuity. So a product defines restrictions on getting your money, and a product also defines the tax treatment. So treatment at death, accessibility to money, and tax treatment. But the product doesn't give it value. What gives it value? The performance of the underlying funds, whether they perform well or not. So when sometimes, and Old Mutual is typically a victim of this, my Old Mutual RA, they are terrible. They do not know what they are doing. That's a little unfair, because all Old Mutual offers is the product, the wrapper called a retirement annuity or a living annuity. It's the advisor that's put you into the wrong fund that accounts for the poor performance. So are you happy with this distinction between the product and the underlying fund giving it performance? Okay, so let's now, so we're happy with this classification of product. It determines the treatment at death, correct. Let's just consider a few strategies over here, and then we'll go through the slides. So here we have a large share portfolio held by husband. Husband none the wiser. This happens all the time, or a unit trust portfolio held by husband invariably. Not always, but more commonly, husband accumulating this over time. And now the husband wants to do some estate duty planning. What would happen if the husband died immediately with a large share portfolio? Number one, capital gains tax. Number two, falls within the ambit of the estate. You agree? So executor involved, estate duty involved, and very importantly, delay, master. I can tell you that the master of the court in the High Court in Pretoria did not pay rent 2 months ago, and they couldn't even house meetings there because they had to go to the Tushers or the Nando's, true, to house their meetings with the master. They weren't paying rent. It's true that. Okay. Okay. So what do you do in a case like that? You don't want to trigger capital gains tax. You don't want this event. As Russell kept speaking, he used, what was the most common word that Russell used? Started with a P and it ended with an N, and it's a 4-letter word. Plan. Okay. As Jake White used to, or always says, if you fail to plan, you plan to fail, right? And it's a cliche, but it's absolutely true, because you can't correct things or remedy things when too close to the time, when it's too late. So plan is key. So what do you do in a case like this? What you do in a case like this is you transfer wealth from one spouse to another. You transfer half your share portfolio to wife. Now, Russell spoke. There's no donations tax when you transfer money to a spouse, just like there are no executors fees. Sorry, there are no estate duty fees when you inherit, when the spouse inherits wealth from the deceased spouse. So no donations tax. So there's no tax disincentive to transfer wealth. The other thing is that a transfer of wealth from one spouse to another does not trigger capital gains tax. It doesn't. All that happens, we all have selective memory, but who has the best selective memory of everybody? SARS. SARS has an extreme selective memory. So what SARS does is they say, I remember that guy, Mr. Walpe. He transferred shares to his wife, and not only that, but the base price of, I don't know, Standard Bank was 50 Rand at the time. Off it goes to Mrs. Walpe, and SARS makes a note. There's no capital gains tax payable, but SARS makes a note that Mrs. Walpe inherited shares at 50 Rand a share, so that when Mrs. Walpe dies or Mrs. Walpe sells the shares, it's whatever the current price of Standard Bank is minus the price at what Russell originally bought for. But the point I'm trying to get across is it's a very effective and immediate way. Remember, everything about this is urgency. That's the key to this. Urgency avoiding the master and trying to reduce estate duty and executors' fees at the same time. So now the wife has half the share portfolio, and the wife is younger and healthier than the husband, and the husband's getting progressively sicker. And what do? You transfer more from one spouse to another. You agree with me? It is more complex when there's no surviving spouse. Why? Because now capital gains triggers, you agree with me? And donations tax triggers. It's easy when there's a spouse because that's the exemption in this law. It's much more complex when capital gains kicks in because you're now transferring wealth to a non-spouse, and donations tax kicks in because now you're going to pay tax at the time of transfer. So that mechanism isn't so simple at that time. Okay, so let's take this further. Okay, so we are quite happy, okay, as to what the objective is with this talk. We want to transfer to the intended beneficiaries. They are the intended beneficiaries with a pension type plan, pre-retirement or post-retirement, are not the same as within your will. You agree with me? They possibly are, but they're not necessarily the same. In fact, the Pension Funds Act requires that you better designate the right people, the financial dependents, within a pre-retirement or post-retirement product. And if you don't, they will do so on your behalf post-death. So you've got to really get that right. Okay. You want to do so as quickly as possible because the surviving spouse or the surviving beneficiaries have bills to pay and immediately to pay. Remind me about offshore. We've discussed past girlfriends and boyfriends, right? Where you made this bequest to Mariki, but Mariki's no longer a financial dependent. Mariki doesn't get the pension fund. The wife gets the pension fund. We'll remind me about offshore. We're going to come to that in 1 second. So we want to do so as quickly as possible. And we want to transfer wealth at the least cost. So what product would allow us, for example, to transfer wealth at the least cost? So if we have a look, I'm just going to go back here. Sorry, Uncle Frank. I'm just going to go back over here. Okay, so if we have a look over here, do you agree with me? We haven't discussed pre-retirement products, but the treatment is that the transfer goes to the intended beneficiaries outside of the estate, not part of it, okay? Straight to wife, straight to children, whatever the case may be. Post-retirement pension, they're even quicker with the process. So again, not in the estate, no executors, it's quick and it's cost-free. So that's where we accomplish that. In an endowment, and I'll come to offshore now, in an endowment where you can designate a beneficiary, then it's also quick. Yes, there are state duties payable, but there's no executor's fee and the process is immediate. Let's discuss offshore. There's something called an offshore endowment. If you use a South African administrator, I reinforce my point. We are the best in the world at administering money. Absolutely the best. Our banking system, as you know, but the investment industry itself, the way that we explain things, the way that we structure our product, the wording on an application form, the kind of continuing education you need, really tops. The only place we lack, and it's difficult to remedy, is sometimes in performance because the market does all sorts of things contrary to expectation. MTN is down 8% today. Why? Because the Nigerian government imposed restrictions on ID and this kind of identification process and that. So the vagaries of the market sometimes make it very difficult to do what the most important thing to do is, and that's to get adequate performance. It's not so easy. Markets do funny things. But other than the vagaries of the market, the structure of the industry, absolutely world leading, not even world class, world leading. Okay, so let's get back to an offshore endowment. So now you now have 3 children overseas. All your children are overseas. Okay, let's consider this scenario over here. And the intended beneficiary of, okay, so now we've got husband, wife, and 3 children living overseas. And they're elderly, and the intended beneficiaries are those children. But they don't want to relinquish or transfer wealth prematurely because they don't know how long they're going to live, and they don't know how much capital they need And they certainly don't want to transfer money prematurely and then go back cap in hand and say, please, can I have my money back because I'm living far older than I intended to or thought I would or my genes suggested or whatever the case may be. So you can't give up your cash too early, right? Unless you've got oodles of it and it makes no difference in the first place, but that's not that common. Okay, so take out an offshore endowment. You use your offshore allowance, the money goes overseas, and you specify on the application form who your beneficiaries are. And the primary beneficiary, your wife. So you predecease your wife or she predeceases you, whatever the case may be, spouse inherits. Spouse now takes the money offshore. It's already offshore, in fact. And there are various ways of doing so. The spouse can continue with the endowment, or the spouse can purchase a separate endowment, or whatever the case may be. Spouse now has an endowment in his or her own name and designates children as beneficiaries. And the remaining spouse passes away in South Africa. Easy peasy logistically. The money goes, it's already overseas. You agree with me? The money is paid speedily to the children overseas. It's recorded in the will. You don't need a separate will because it's coordinated, administered, managed by a South African administrator. It's considered to be local. And local is lacquer, right? So it's considered, so you don't need, it's not subject to, if you like, offshore probate, international probate. And that also simplifies things. In fact, South African administrators have gone to great lengths to simulate, to reproduce the experience of investing overseas as you would invest here. The forms look the same. The process is the same. Accessibility to the investment is the same, except instead of seeing R rand signs, you see dollars and pounds or whatever you look at. But the experience is very similar. So that is an example of how you would speedily get money to beneficiaries, how you would circumvent the master, because that's the primary over here. Circumventing estate duty with these babies over here, not so easy because subject to estate duty, correct? Okay, so that is the essence of the industry. Am I talking too much, Uncle Frank? No. Okay. Okay, so let's have a quick summary. Are you happy with the summary? Okay, so I just want to come back to my initial question. We had 20 minutes to understand the investment industry. And we said, let's just see how well we've done, right? So we classified the stages of investing between the accumulation phase, where we're putting money into the investment for some future time, and the drawdown phase, where we're paying ourselves back, if you like. We made a distinction between retirement funding money, where you got to, you know, you got to be far more careful who you designate as a beneficiary. It's more strictly controlled than money that falls within the ambit of your will. In fact, pension fund money doesn't fall within the ambit of your will at all, thank goodness, the ambit of your estate, governed by your will. Okay. The other important thing over here is we said that you're going to have this pot of money, your final company pension fund, a few preservation funds that from previous employers that you had saved over the years, a few retirement annuities that you were correctly or incorrectly or missold. And you're going to sit with a pile of investments, retirement funding products, pension funds, preservation fund, 3 preservation funds, 4 RAs. You're going to take all these babies. You're going to total up the amount. It doesn't matter from which of the investments it is. And you're going to purchase your pension over there, right? That's what you're going to do. Similarly, by the way, you could have had discretionary money, a share portfolio, company retirement linked gratuity or bonus. You could have a pile of, if you like, non-pension money. And what are you going to do with that? You're going to draw it down to pay yourself an income. Do you agree with me? And the beauty about doing that, by the way, is that it's not subject to tax. Because a pension that you receive, there's only one tax table, pay-as-you-earn tax table. There's only one, whether you're retired or whether you're 22 starting your first job. The pay-as-you-earn tax table is the table that applies when you draw pension. There are no great reasons to aspire to be 65 or 75 in terms of saving tax. I promise you it's overrated. It's overrated. You'd rather stay young and pay slightly more tax. And that's the best advice I can give you. Stay young and pay slightly more tax. Okay. but it is subject to the pay-as-you-earn tax table. So when they say, what was this talk about? You're going to say, to transfer wealth as quickly as possible and to stay young and pay more tax. I mean, those are the two takeaways from this talk. Okay. So, but let's come to this. Is that right, Uncle Frank? Sorry. Okay. So, so let's go. Always Uncle Frank. You know, it's like calling your headmaster by his first name. You can't ever do that. I can call Uncle Frank. I'll never do that. Okay. So if we have a look at your discretionary money, if you start to draw 20,000 Rand a month from your share portfolio or your unit trust portfolio, that's not taxable income. All you're doing is you're simulating a pension, but they really are draws of capital. It's analogous. It's identical to going to the ATM and saying, thanks, I'll have 20,000 a month. It's exactly the same, except you're getting more money than you would in investment return than you would in the bank. But it's the same process. So it's a great way of drawing down tax-free income and maybe taking less of a pension that is taxable. Okay. Things like, so we've discussed these discretionary investments. The fundamental investments, by the way, money in the bank, shares on the stock market, maybe you invest in government bonds. Those are the primary asset classes. And if you want someone to manage your money for you because you do something completely different in life, you can't possibly keep up to date. So pay them their 1% fee and let them do their job that they believe they're so good at doing, okay? And invest in a unit trust fund. Some call that a hedge fund. It's a pool of money that someone's managing on your behalf. Things like structured products and derivatives are all derive their value from the value of certain shares. So it's just fancy mathematical ways of deriving value from the trend of Standard Bank or Naspers or Anglo-American or whatever the case may be. But the primary assets, money in the bank, cash, shares on the stock market, maybe government bonds, and then someone will manage it for you. So this is and post-retirement, you're drawing down on that to pay yourself a bit of an income, maybe to supplement your pension, et cetera, et cetera. That's the investment industry. There's nothing more. Everything else is an extension of these fundamentals. So do you like this chart, this diagram? Me too. You want to know why I like it? Because I did it, yes. Okay. Okay. Uncle Frank is saying we're going to call it a day, but we can't call it a day until we summarize. Then we can call it a day. Okay? Is everyone still awake? Okay, I mean, that's fundamental, right? We need to be awake. Cheryl, are you awake? Okay. All right. Okay. So let's just go through the range of products because the treatment at death is governed by the type of product. That's why we had to spend so much time, monotonous time, on going through the range of products, because that's the treatment at death. So let's go through this together. Do you agree with me? Let's go to the first four. They're all your retirement funding products, and you can designate a beneficiary. You agree? And whether you designate the right one or the wrong one, it's going to your financial dependents, your spouse and your children. It is. So you might as well do the right thing in the first place and not upset the trustees of the pension or provident fund, okay? They're not governed by your will. They're not. That's a good thing. Cash can be, so it is possible. What we haven't discussed is, can beneficiaries take money out of these things? Because now you've got a child or a spouse that doesn't want the pension. They want the cash because they live overseas or they want to build a house. There are ways by which you can take cash out of the investment. But what's the disincentive in taking out cash from a deceased's pension fund? The government is very clever and very reasonable in this. What the government wants is they want the beneficiary to purchase a pension immediately. In other words, to extend their money as long as possible, rather than, if you like, squandering their money too soon. So the government comes up with a compromise, and the government says the following: you can take the money, you can take all of it, you can take some of it. The general rule in this country is whatever you take and put into your pocket, rather than putting into a pension, is potentially subject to tax. That's the deterrent. So they want you to take only so much, but more than that, they're going to tax you. Yes, they do want the tax, but the primary motivation is they want that money preserved. They don't want you to squander that money prematurely. So let's have a squiz quickly. Frank, I'm talking too long, but Can we have 5 more minutes? Okay, any objections? Frank, it's overwhelming. Uncle Frank.
Thank God I'm broke.
Okay, all right. So husband dies in a pension fund. Husband dies in a retirement annuity. Husband dies in a post-retirement living annuity. They want you to transfer money into a pension of your own. If you take more than 500,000, we won't go through the details, but the point here being, the objective, the rationale, is they start to penalize you if you take more than your tax-free allocation. Unfortunately, it's not per investment, it's per person. So there are 5 retirement annuities. The first retirement annuity, you can take the first 500,000. But the second retirement annuity, remember we spoke about selective memory? SARS says, Mr. Walpy, he took out 500,000 from a retirement annuity. And now he's taking out another 500,000 from a second retirement annuity. So poor Mr. Walpy starts to pay 18% tax on the next 200 he takes out. And then he starts to pay 27% on the next 350,000. The purpose, the rationale is it's a disincentive to take money out of a retirement funding product. So I want to go back to where we were. Yeah, we were here. Okay, so you can take out cash, but there's a potential tax implication for your beneficiaries. Remember, this is an interesting study, as Russell pointed out, because we're not talking about ourselves here, are we? We're talking about benefits to those that will inherit from us. So some of the things we do are not in our own, in fact, they're not in our own interests. They are in the interests of those that we care for and we protect financially. It's not about us, this, right? I mean, that's an interesting analysis about this whole talk. It isn't about us. It's about those that we leave behind. And the applicable tax, if you draw money, the tax table I've just shown you, first 500 tax-free, you're going to start paying tax, not you. Your beneficiaries are going to start paying tax. It is their consideration, obviously, because it's up to them to decide how much of the money I've inherited from my living annuity am I going to, in turn, invest in another living annuity, and how much am I going to withdraw as cash? And the amount I withdraw as cash is potentially subject to the tax table, potentially subject to tax. Okay, so this living annuity is a post-retirement pension. Beneficiary nomination, we agree. Governed by your estate, no, because the beneficiary needs money immediately. Cash paid out in a lump sum, yes, you can. But remember, the first 500,000 tax-free. Beyond that, you start paying tax as a disincentive for the beneficiary not to withdraw it as cash and rather purchase a pension in his or own right. A guaranteed annuity, those are the ones who I spoke to earlier, where you get a fixed income for life with possibly an escalation. Now, there's no capital that passes to beneficiaries. Remember, I mentioned that as one of the shortcomings. Capital is not intergenerational. So beneficiary nomination, depending on what variation you purchased, sometimes nothing is paid to the surviving spouse. Sometimes it's payable for the first 10 years of the policy. Sometimes it's payable for the life of the spouse. It comes in different variations. Governed by your will? No, it's not. Retirement funding products, everything from guaranteed annuity upward, not governed by your will. Doesn't fall in your estate. Cash paid out at lump sum? No. One of the shortcomings. Applicable tax? It's income. As you earn tax table, as if it was salary, right? Okay. And then we come to the discretionary, the bottom part of the charts that you see. Share portfolio, no beneficiary nomination. That falls within, governed by your will. You agree? Falls within the ambit of your estate. Governed by your will, yes. Yes, you can take cash out. You'll be paid by the executor, by the estate. Applicable tax, estate duty, correct? Beyond the exemption, 3.5 million. Unit trust, the same. And the endowment, what differentiates the endowment over here? The beneficiary nomination. Money gets to the intended recipient immediately. Both a local endowment, an offshore endowment, whatever. Governed by your will? No, because there's provision for beneficiary. Cash can get paid out? Yes. Applicable tax? Estate duty. So as you can see, those are the products or the primary products. Everything is a derivative of one of those, and that's the tax treatment and the treatment to death. Any questions? Yeah.
Life policies and endowment policies, if they've been included in the will, but they have to follow the will.
Okay. Now, that's a good question. They shouldn't be. The intended purpose is that they're outside of the will. Do you agree? Okay. So if sometimes the intended beneficiary is the estate, it defeats the object. It absolutely does. It makes absolutely no sense. It is counterproductive in every way. The merit of an endowment, there are a couple. There's tax treatment that's favorable for those paying more than 30% tax. Well, I haven't discussed that. But in terms of the transfer of wealth with great speed, beneficiary nomination. So it makes no sense at all. Well, the endowment person's still alive, the investor. Okay, so it's too late. Now it's inside the ambit of the estate. Yeah, too late.
Sir, I just had a letter from my insurance company. We had more than one annuity. And now SARS is saying that's a new percentage that you'll pay every month.
Got it, yeah.
Now, what I want to ask you is it better to go with the new idea or stay on the tax that you're already paying?
Okay, so here's a question. Everyone got that letter, I think? Danny, can you help here? No, you don't have to help. So let's do this. Okay, so let's have a quick squiz over here. It's just come in, right? So I'll tell you the context. So let's go down to here to answer your question. Okay, so we're going to our product sheet and we're looking at annuity, guaranteed annuity, living annuity, one of the two variations. Doesn't really matter which it is, but let's assume that annuity, pension number 1 is with Alan Gray. Pension number 2 is with Sanlam, and you're working, or you're earning additional income from interest or whatever the case may be. Okay. When Alan Gray taxes the income that you receive from that pension, in the past, it only knew about that income. That's all it knew about you. And what was it doing? It said, you're drawing 226,000 Rand. We're going to subject your income to 18% tax. And we're going to apply the rebate nochal, and you're going to land up paying no tax, right? And Momentum did the same thing because you only drew 226 from them. And you were drawing an income elsewhere that nobody knew about. Certainly neither Momentum nor Alan Gray. Now you submit your tax return. Now you're going to add this income to that income, to that income, to that income, and it drives your marginal rate of tax all the way up. And your accountant, Russell's the guilty party. He says, you owe 60,000 Rand. And Russell says to you, 24 hours. And you say, I don't have the cash. And Russell says, but SARS ain't so understanding. And that's the complexity because they under-deducted initially. And people didn't have the cash to add, if you like, to settle the shortfall at the time of assessment when your tax return was submitted. So now what they want to do is they've now gathered income from all sources. They've determined what your likely tax rate is. So to lessen your burden at the time of assessment, they're now deducting more tax. That's the practical reason for that. Okay, now that's a good question. So you can opt out. So if you opt out, there's a cash flow benefit up until the time that you need to go and report to Russell. You agree with me? So your cash flow is improved. You agree with me? And then they clap you later. And hopefully that you have enough money to settle that shortfall. So there isn't, if you like, there's an immediate cash flow advantage, but at some point in time, you'll need to settle that liability and make sure that you have enough money to do so. Yeah.
The rate that they're charging now is saying 18%.
Yes, that's a, yes.
I would be charged maybe about 20% if you look at the tax.
Yes.
Okay. Now, they're saying basically about 18%. So you look at go with a new idea.
Well, it depends on your cash flow needs now. Yeah, it depends, but at some point in time you'll have to settle it. Yeah, yeah. Maybe if you don't want this additional shortfall to be compensated. Yeah. No, you don't need a directive. No, there are no formalities. You just return the form and say, no, keep me where I was. No directive, no formalities. Then they will take no tax, or they will take, they'll take the tax as if this was your sole source of income in isolation. Yes, as you were. Yeah. If you say no. And better than that, you can change your mind during the year, as you can. So it doesn't have to be only on anniversary, on review of the annuity. It doesn't have to be.
Okay, I think that is enough time to have a rest. I'm going to work out your problem. I'd like to say thank you to my nephew. Thank you all for coming. Thank
Okay. So if husband sits with a large share portfolio and he transfers it to the spouse, there's no capital gains tax implication on the transfer.
Yeah.
So there's no deduction of money. 1,000 shares worth 100,000 rand land up in the spouse's name, the wife's name. However, you need to record what the base price is at which the husband originally purchased them. So Standard Bank was bought by the husband at 50 rand 20 years ago. That's the base price. That is the base price on which capital gains will apply in the future when the wife sells those shares. So there's no way of lifting the base price if you like. So they give you, it's a great concession because you can transfer wealth. Husband dies, wife sits with a share portfolio immediately accessible to cover her bills. But they remember the capital gains implication. But worse off because the husband would have paid it, right? You're just transferring that lower base price to wife. No, you don't at the time of transfer. So let's assume that husband buys Standard Bank at 50 rand in 1990. It's now worth 150 rand, Standard Bank. He transfers his entire Standard Bank share portfolio to wife. She gets all those shares. But
Hi everyone, I don't know if you can still hear me. Sorry, I had a system crash on my side, so I lost everything. I hope you still were able to hear the last short bit. I've lost all the questions, so if you asked a web question, please can you email it to me and I'll email the presenters and ask them to answer your questions as best they can. We'll probably do another wills and estate talk later in the year, hopefully more structured and probably carry on as a webinar. But this was just a talk in person and we were trying to work it as a test. So I hope you enjoyed. If you didn't, I'm sorry. All the best. Have a good day.